How is it possibly acceptable that a man convicted of a sex offence of the worst kind against a 13-year-old girl does not go to prison, whereas somebody like Lucy Connolly, after a single tweet where she was accused of inciting racial hatred, gets a prison sentence of 2.5 years. Similarly, in a very recent case, an illegal migrant was also spared jail despite being described by the prosecutor as being very drunk and in possession of drugs whilst he repeatedly punched female police officers in the face. Comparing that somewhat randomly with another case, you'll recall a man was jailed for 20 months just for shouting at a police dog and using racial slurs in public. Now, these are not isolated cases. Many men that have been convicted of serious offences escape prison, and yet many people that are convicted of what you might think of not such a serious offence get significant prison sentences. Now, each of these cases must be assessed on their own facts, and some of these sentences have been appealed. For example, there was one case about 12 years ago where the sentence the guy received of a non-custodial sentence was referred back to the Court of Appeal by the Attorney General and then increased because the Court of Appeal considered that it was an unduly lenient sentence. And so he actually ended up with a 2-year prison sentence. But a 2-year prison sentence for such a serious offence, you may still think, is not even close to acceptable. So as a society, do we really think these punishments are fit for purpose and suitable for the offences committed? Now, that's a really interesting question. And what's more interesting is whether we consider this system as working or an old, outdated and broken system. In fact, this was my comment that stood out to the journalist that interviewed me for a piece for The Times, where I said the whole legal system is dated and clunky. And of course, what I meant by that is that both as a citizen and as a barrister, I think much of the legal system is indeed dated and doesn't necessarily reflect what we think as a society, particularly when it comes to the punishment of offenders. Well, I've had the great pleasure of previewing a TV programme presented by Anne Robinson that addresses these very questions, called You Be the Judge. It will air on 5 on Tuesday the 6th of May at 9 p.m, and of course it will be available on channel5.com. Now, it was an honour to be asked what I think of the programme and to explain a little bit to you from my perspective on what underpins each of these questions. Now, my immediate reaction when I was told about this programme, which I think is interesting in and of itself, is that not only does this sound like a fantastic programme, because I think it deals with very serious issues that doubtless the entire nation will be concerned about, but that I also felt that people will get this wrong. You see, the way the show works is they reconstruct real sentences of real cases with real offences and real people. And then they ask different groups of people what they think the punishment should be for each of those. And as I say, my immediate reaction was I think people will get this wrong. Now, why is that? I think that is an interesting question in and of itself, which is sort of leading and informing, if you like, the content from my video here to tell you things that I would like you to keep in mind when you watch this program. Because I think if you go into this program with a bit of information from me as to how these things work, the show does explain how these work as it goes along as well. But I think you will then form a view of your own, not just of the legal system as a whole, but specifically the criminal justice system and the punishments we impose upon offenders. So allow me, if you will, to take you back to school, a virtual bar school, if you will. Because it's at bar school, training to be a barrister, that we first learn about sentencing guidelines, aggravating and mitigating factors. Those are factors that would make a sentence more severe or less severe, depending on the particular circumstances of the case. And how we put a plea of mitigation. That is where, as a defence barrister, you are pleading with the court to impose a lesser sentence on your client, whereas the prosecutor will be arguing for a more severe sentence. But that really is the whole balancing act. You'll picture the set of scales upon the courts of justice. That is balancing justice. Because I always say that it's incredibly important that every case is prosecuted and defended equally fearlessly and fairly. Only then will we get a fair outcome, because it all depends on the burden and the standard of proof. In the civil courts, it's on the balance of probabilities, i.e., is it more likely than not that a thing happened, and then the court can make a decision. But in the criminal courts, we do have the burden of proof lifted to what we refer to as the criminal standard, so that there is no reasonable doubt, or the way that it's directed in court, so the jury is sure, or indeed in the magistrate's court, the bench is sure that the thing happened. Even before you get to bar school, i.e. to practice as a barrister, you're expected to have studied law to degree level or a graduate diploma in law if you did a non-law degree, to give you a broad understanding of criminal offences, how they're prosecuted, the mental element and the act element, the mens rea and the actus reus, and to understand the elements of an offence and how an offence is prosecuted. But in my experience practicing as a barrister, there is a real disconnect between what people expect and what the law says a sentence should be. Now, in my life, I've coined things like this with the phrase system and reality. The system is what it's supposed to be, and the reality is often somewhat different. So let's first talk about the word sentence. You can think of a sentence as the period of time for which the offender is subject to the order of the court, which may or may not be spent in custody. It may be spent working in the community. But let's say a 2-year sentence is imposed. The offender will typically serve half of that in custody and the other half on licence in the community. So they are still subject to the order of the court, and they can still be recalled to prison for the remainder of that full sentence if they commit any further offences, or they fail to adhere to any requirements such as banning orders, reporting orders, rehabilitation orders. These we call ancillary orders and so on. All of which designed to rehabilitate and in some certain ways to punish the offender for what they've done. And also to restrict further offending, let's say, from within a certain area. So football offences will typically attract a football banning order, so it will ban them from further matches. Offences that are committed in the town centre, for example, there'll be an ancillary order to ban them from the town centre, and so on. But that is typically what a sentence is. But then when we think of a life sentence, it doesn't mean, as some people do think, that it means that they will spend the whole of their life in prison. Indeed, they might do, but that would then be a whole life order. A life sentence means that they will be subject to recall to prison for the rest of their life, however long they've served in custody. That is when we get on to minimum sentences, the minimum time that they will serve in prison. This was of significant discussion and frustration in the Rudy Cabana case because of his age. But age is, of course, one of the elements the court will consider, i.e. the court cannot make a whole life order for a person who was not at least 21 years of age at the time of the offence. But there are two elements that have a significant and material impact on the net effect of any punishment imposed by the court. Those are, in reverse order, first of all, whether they plead guilty because they get a reduction of their sentence. We call that credit for a guilty plea. And the earlier they plead guilty, the more reduction they get, typically starting with 1/3 of the sentence. And that is at the earliest opportunity to indicate that they will plead guilty. And then that reduces and tapers off until they finally get to trial, where it all but disappears, unless, of course, they plead guilty before the trial commences, in which case they might get a slither off the sentence, but it'll be a significantly lower reduction than if they plead guilty right at the beginning. But the second, and probably least understood element, is that of the sentencing guidelines. These are guidelines that the courts must follow. Indeed, they are at liberty to depart from the sentencing guidelines, but that might leave the sentence open to appeal. And there's another way of appealing the sentences as well, which I'll come back to in a moment. But the sentencing guidelines, if we take, for example, this very serious assault, which you can see on screen here, it's triable either way, meaning it can be either tried in the magistrate's court or in the Crown Court, depending on the severity of the offence. And it carries a statutory maximum of 14 years custody. Now, the way the court determines the sentence is by first determining the offence category. And that is usually decided by looking at the harm factor and the culpability factor. The harm is the physical or other psychological or other harm caused to any victim or anybody else, or society in general. And the culpability is how responsible the offender was for that particular offence. For example, there's a big difference between being caught up in something and you do something very minor, but there was no planning, there was no motivation, there was no exploitation or anything else. On the other hand, it might have been an offence with a significant degree of planning, specifically designed to target vulnerable victims and so on, in which case that would be a much higher category of culpability. And so the court will then take each of these elements that are present in the facts of the case, on the surface, many of which may not seem relevant or valid to members of the public, because remember, as a society, we look at the net effect of this offending on the victims' families, and society as a whole. So the victims, the families, and society in general may not really care that there wasn't a significant degree of planning involved if a person has lost their life or been severely injured by this attack. As a matter of law, the courts will look at these sentencing guidelines as factors to consider when arriving at the sentence. And the sentences are then set out by way of guidelines in these categories here. And it's this process here that may look oversimplified and, in my view, may result in sentences that many of us simply don't agree with. And of course, the court is also required to consider the dangerousness of the offender and what we call the totality principle, meaning if there's more than one offence, they will be considered together. And so does the ultimate punishment reflect the totality of the offences committed? And not least, the victim impact statement, so the court can consider the impacts that these offences have had on the victim, their families, and society as a whole. Whilst those statements, of course, don't dictate the sentence, it does allow the court to pass a more appropriate sentence. So again, bearing in mind the serious nature of this offence that we're looking at in this particular sentencing guideline here, we look down at the categories. If we are looking at a category 3B, for example, the lowest harm category being that where factors in category 1 and 2 are simply not present, so it wasn't prolonged or it didn't involve violence or threats of violence, etc. And the lowest culpability, so again, where factors of the category A culpability are not present. So there was no significant degree of planning. It wasn't any kind of deliberate isolation or exploitation. If all those factors were not present, the court will then come to look at category 3B, which may result in a non-custodial sentence, despite this being a very serious offence that carries a maximum of 14 years custody. So as you are watching You Be the Judge on 5, listen to the comments of Anne Robinson and how she guides you as to what to think in line with what I've just said in relation to these offences, bearing in mind what I've said, and think of it in two senses. Both how would you feel as the victim, or how would you feel as a member of society, and whether this punishment fits the offence. And on the other hand, think of it from the court's perspective, looking at these lists of categories, and maybe even have these open when you're watching the programme, and see if you can tick off any of these factors that are present or not. So as you're listening to the description of some of these offences on the programme, without giving too much away, of course, you can weigh up these factors from the court's perspective and see what you might think if you were the judge. Was there a significant degree of planning involved? Was the location of the offence something that should make it more serious? Were there steps taken to conceal evidence? Were they cooperative with the police, or were they evasive and tried to cover their tracks? All of these things should have a material impact on what the court decides in the sentence in the end. However, it may ultimately end up in a sentence that you simply don't agree with. And finally, I'll leave you with one or two big questions to ponder. If it's not the sentencing guidelines or other case law that has this material impact on the sentence, could it indeed be more politically motivated aspects, such as the prisons are full to breaking point? Or is there a political move towards rehabilitation as opposed to punishment, which some countries have adopted with varying levels of success? And finally, as a society, do you think we should have more of an input on how long these offenders actually spend in custody? Let me know what you think in the comments below. This airs on Tuesday, the 6th of May on 5, and of course it will be available on channel5.com for much longer. But I thought this was a fantastic program and I encourage you to watch it. So thank you for watching this, keep it in mind, and I'll see you next time.